Up next, a conversation with Supreme Court Chief Justice John Roberts at the University of Minnesota Law School in Minneapolis. He's asked about several topics, including the public's perception of the court, how it operates, and whether cameras belong in the courtroom.
Thank you. Thank you very much. I appreciate that. Thank you. Thank you. Thank you very much. Thank you. Before I sit down with Professor Stein for the main event, I thought I would spend a moment or two touching upon the contentious events in Washington of recent weeks. I will not criticize the political branches. We do that often enough in our opinions. But what I would like to do briefly is emphasize how the judicial branch is, how it must be, very different. I have great respect for our public officials. After all, they speak for the people, and that commands a certain degree of humility from those of us in the judicial branch who do not. We do not speak for the people, but we speak for the Constitution. Our role is very clear. We are to interpret the Constitution and laws of the United States and ensure that the political branches act within them. That job obviously requires independence from the political branches. The story of the Supreme Court would be very different without that sort of independence. Without independence, there is no Brown versus Board of Education. Without independence, there is no West Virginia versus Barnett, where the court held that the government could not compel school children to salute the flag. And without independence, there is no Steele seizure case, where the court held that President Truman was subject to the Constitution even in a time of war. Now, the court has from time to time erred, and erred greatly. But when it has been because the court yielded to political pressure, as in the Korematsu case, shamefully upholding the internment during World War II of Japanese-American citizens. Those of us on the court know that the best way to do our job is to work together in a collegial way. Now, I'm not talking about mere civility, although that helps. I am instead talking about a shared commitment to a genuine exchange of ideas and views through each step of the decision process. We need to know at each step that we are in this together. There is a concrete expression of that collegiality in a tradition at the court that has prevailed for over a century. Before we go onto the bench to hear argument in a case, and before we go into the conference room to discuss a case, we pause for a moment and shake each other's hand. It's a small thing, perhaps, but it is a repeated reminder that, as our newest colleague put it, we do not sit on opposite sides of an aisle, we do not caucus in separate rooms, we do not serve one party or one interest, we serve one nation. And I want to assure all of you that we will continue to do that to the best of our abilities, whether times are calm or contentious. Thanks very much. Thank you. Okay, good. Thank you.
Well, let me welcome you to the University of Minnesota Law School. Thank you for being here, Chief
Delighted
Justice
to be
Roberts.
Here. Thank you.
I'm glad we have good weather for you today. I think you told me the last time you were in Minnesota it was January.
It was in January to argue a case in the Court of Appeals. I came in on Sunday, and I had never been to the Court of Appeals here before. And I always like to go, visit the venue before the day of argument. It we were staying, I think, in the St. Paul Hotel or something. Anyway, the courthouse was very close, so I figured I'd just go take a look, maybe 5 blocks. After about 2 blocks, I turned back and said, I'm sure I'll find it in the morning. My wife lived, shortly after law school, worked here, as she puts it, for 3 winters.
Well, we're delighted you're here and that we have a wonderful sunny day to welcome you while you're here. And to all of you, students, attorneys, and friends, totally filling this 2,700-seat auditorium, thank you all for being here as well, and welcome. This is the format we're going to follow this afternoon. The Chief Justice and I will have a conversation until about 5 o'clock. And following my questions, there will be an opportunity for you to ask Chief Justice Roberts questions. Microphones have been placed on both sides of the main floor of the auditorium for you to ask your questions of the Chief Justice. Please remain in your seats during my conversation with the Chief Justice. So, Mr. Chief Justice, let me begin our conversation with this question. Your position, Chief Justice of the United States, is a position recognized in the Constitution, and the Associate Justice positions have been created by statute. Indeed, the size of the court has changed during time from the original 6 all the way up to 10 during the Lincoln administration, and it's been at 9 for the last 150 years. How is your position as Chief Justice different from the other 8 associate positions?
Well, the most important difference is that I get $10,000 extra. That's sort of the start at the important stuff. In many ways, it's different. Obviously, in the most important, it's not. I have 1 vote. I participate in the decision-making of the court like any of the associate justices. I have other responsibilities, some of which are absolutely fascinating. I am something called the Chancellor of the Smithsonian, which means I preside at their Board of Regents meetings, and it's absolutely fascinating, because I'm not expected to know anything about what they're talking about, but do get to participate. I am the chairman of the Judicial Conference. That is the body that establishes rules and regulations and policies for the lower federal courts. And that takes a good amount of time, too. Those are the most important things.
Do you speak first in your conferences after a case?
I do. So I have some responsibility to, lay out the case, and I I monitor the discussion. I insist that nobody speaks twice till everyone's spoken once. I try, if there's a, extended discussion, to make sure both sides have a chance to sort of fully air their agreements or disagreements.
One of the powers you have as Chief Justice is to assign the writing of the opinion if you're in the majority in a case. What considerations influence you which justice should receive the assignment?
Well, there are several, and I should say I enjoy that part of the process very much. It's like a riddle or a puzzle to try to get everything to fit together. The first thing is a jurisprudential consideration. For example, you could have 8 people voting to affirm, but for a variety of different reasons, I need to make sure that the assignment goes to somebody who commands the most votes, even though they're voting in favor of the same result. Getting the work done is an important consideration. If it's April and one of my colleagues has 3 opinions that haven't circulated yet, I'll be reluctant to give that colleague a new opinion. I'll give it to somebody else who's more likely to get it done on time. I like to make sure they have a mix of easy opinions and hard opinions, unanimous opinions and closely divided opinions, big opinions in terms of things that are interesting more broadly, and what we call the dogs that aren't. I like to make sure there's a mix in subject matter. I don't want at the end of the year to look and see that Justice so-and-so has done only criminal law opinions. That's not a good outcome. And I even try to make sure that there's not a steady repetition of people being on the opposite side of opinions they're writing. So if 2 people have had, a sort of what passes for a knockdown, drag out at the court, I'll try to make sure they have joined each other's respective opinions in the next assignments. And it's like one of those, I don't know if they're popular anymore, Rubik's Cubes, that as soon as you get things lined up on one axis, okay, there, everybody has the right mix of unanimous and divided cases, you turn around and find out, well, but that leaves so-and-so with nothing but business cases, so you want to switch that, and it's a nice puzzle, and I feel good when it gets pulled together correctly.
Did the justices lobby you and say, Chief, I like that case?
They don't, and it's something I appreciate very much. I think they understand that there are a lot of factors that go into it, and that it wouldn't be very helpful for them to suggest that they'd like one case or another. And I also think they appreciate that I would regard that as a bad thing if they were to ask for a decision, so they wouldn't likely get it.
You made some remarks at the Fourth Circuit Court of Appeals conference earlier this summer and said, quote, I feel some obligation to be something of an honest broker among my colleagues and won't necessarily go out of my way to pick fights. You would sort of sublimate your views. Can you explain what you were saying?
Sure. Well, if you just think of it in the conference room, we're all around a nice table, and we're having a healthy debate about a case. Someone has to kind of moderate it, and I will, although I'll have views probably one way or the other, sort of not jump in right away, because then people would think, you know, I'm trying to be fair in terms of you can talk now and then you, and if I were jumping in on one side or another, that would be a pretty hard role to fulfill. So, you know, I'm going to have an opportunity to express my views, and I will, but at least initially I kind of like to make sure the views get fully aired. And you know, it's hard to do if you're one of the ones talking.
Yeah. The court sat for the first time this term just over 2 weeks ago on the first Monday in October, and this year there were 8 justices on the court when you first sat, and that was also true a couple of years ago when Justice Scalia died and before Justice Gorsuch was appointed.
Right.
What, if any, are the differences when the court sits with 8 justices as opposed to 9?
Well, it's a lot harder. Very few courts have an even number of justices for obvious reasons. And in the federal system, if it's a tied vote, really nothing gets done. The decision stays as it was. It's affirmed by an equally divided court. But there's no opinion, there's no guidance. It's a real waste of time for everybody. So even when our initial vote is 4-4, we try to find ways to do something that moves the case along. In other words, it may not be a decision on the issue that we'd hoped to decide, but if there's some area in which we can come to agreement, you know, sometimes perhaps an insignificant issue, but one that has to be resolved, we'll do that just so the case continues rather than being sent back without any resolution at all.
Now, the court is now back to 9 justices as a result of Justice Kavanaugh's confirmation as a new member of the court, right, succeeding Justice Kennedy. Can you describe how the court changes every time there's a new member that joins the court?
The first thing that happens, I think, is that the 8 who were there before behave themselves better. It is like having a new in-law at Thanksgiving dinner. You know, Uncle Fred will put on a clean shirt, the sort of thing. But and there was certainly evidence this past Monday. A number of people commented to me that the oral argument was very well conducted. Usually people are jumping on each other's questions, but nobody was doing that. But it also, I think, causes the rest of us to sort of take a harder look at some things that we might have taken for granted. You know, for 13 years, I've been explaining my view of a particular clause to my colleagues. They know it, they know what I think. And now you get somebody new, and you kind of have to explain it a little more thoroughly because he or she hasn't heard it yet, and it causes you to take another look at it. So I think there's a lot of, I wouldn't go so far as to say re-examination, but a new articulation of a particular view, and that may cause others to look at it a little more carefully.
Before we move on off of this subject, I would like to ask you to comment about the departure of Justice Kennedy from the court, who served the court so long and was the senior member of the court at the time he retired.
He was an extraordinarily consequential justice in terms of his impact on the law, but he was first and foremost an incredibly kind and decent man to all of his colleagues. Particular help to me and my responsibilities as Chief Justice, as someone who had been there for a long period of time. Extremely thoughtful, careful, considerate. There's something he did that, in a tribute that's coming out by me in the Harvard Law Review to him, that I set forth. He compiled a list of readings that he thought was essential, as it was for his grandchildren as they were growing up, for people to read to understand the concept of liberty. It goes all the way from ancient Greek readings up to the movie Legally Blonde. It works. Believe me, it actually works where he has it. So I'd really recommend people to get a real sense of the understanding of the Constitution and liberty and the scope of his learning to get a hold of the list. I don't know when the Law Review is going to have it out, but I'm sure you can get it online. It's a remarkable reading list to give you an insight not only into liberty and under our Constitution, but a remarkably well-read, very decent individual. I'm going to miss him.
Well, he had a big impact on many of us when he heard I was going to teach a course in great cases at the law school as I left the ABA. He said, let me see that list. What cases are you picking out? And he insisted that a couple of cases be added to that list, in his opinion. Many of the people in the public don't know very much about the Supreme Court. I recall surveys when I was at the American Bar Association finding that as many as 15% of the public couldn't name a single justice on the Supreme Court. An Annenberg Center study found that 10% of those surveyed identified Judge Judy as a justice on the Supreme Court. Is this lack of knowledge about the court a problem, in your opinion?
Well, yes and no. The lack of knowledge about how the Supreme Court functions, and in particular how it is different from the political branches, is very unfortunate. I think too many people think that when we reach a decision on a case, it's pretty much the same as Congress reaching a decision on a question of policy. And of course, it's not that at all. It's very different, and people need to know that. But I'm not bothered by the fact that they can't name people. In some sense, I think that's probably a very good thing. We wear black robes to convey the notion that our individual views, personality, does not have anything to do with the function we have to play in terms of coming to a correct decision on the law. So I don't feel any need to have people know the individuals who are performing the work of the court, but they do need to know how the work of the court is different from that of other entities in the government.
Are there times when you move in public when you're not recognized by?
Oh, sure. Generally, I'm not. And interestingly, when I am, I would say almost 99% of the time, the people who come up to me are very nice. They either say something, how much they like what I do, and even the ones, I don't keep track of how many, but who don't agree with me, they'll come up and say they appreciate my service, but they don't agree. And sometimes they'll be very effusive in praise for an opinion of the court and say how great the court was when it did this and how important it was and how pleased they are. And I just don't have the heart to tell them I was in dissent. So
Do you think that allowing cameras in the court would be helpful in the work of the court or getting more people familiar with how the court operates?
I think it'd be very helpful in getting more people familiar with how the court operates. But that's not our job, to educate people. Our job is to carry out our role under the Constitution to interpret the Constitution and laws according to the rule of law. And I think that having cameras in the courtroom would impede that process. We think the process works pretty well. I think if there were cameras, that the lawyers would act differently. I think, frankly, some of my colleagues would act differently. And that would affect what we think is a very important and well-functioning part of the decision process. I don't think there are a lot of public institutions, frankly, that have been improved in how they do business by cameras. Senator Howard Baker told me at one point that he thought the televising of the Senate proceedings, I think he used a strong word, I'm sure it's not right, whether it's ruined or certainly hurt the proceedings in the Senate. People have an absolute right to know what we're doing, and that's true in courts around the country. We have an open courtroom. I think it's to a certain extent unfortunate that we're not televised, because I think most people would be pleased with what they saw in terms of how seriously we take our work and the high level at which the exchange is conducted. But I do think it would have an adverse effect on our job under the Constitution, and that has to come first.
Now, you release your oral recordings, is it the next week after the argument? Or?
Right, right. Transcript is available within an hour, and the oral recordings at the end of the week.
The opinions of the court receive a great deal of comment, some favorable and some extremely critical, but the justices let their opinions speak for their decision. Are you ever tempted to respond to a criticism that you think is really wrong-headed and the critic just doesn't get what the issue was and what you decided? And how do you deal with criticism of your opinions?
Well, I try not to read it, frankly. I mean, well, in most of the cases, for the regular commentators, you can figure out what they're going to say once you see the byline. And the good thing about life tenure is that it really doesn't bother you that much. And in some cases, it's unlikely that the criticism will be any harsher than, you know, in the dissent, from my opinion, or whatever. But, you know, frankly, I read legal commentary. In other words, things that I think will show, you know, a thoughtful analysis of, you know, things that might have been written better, and to see if there's an understanding about what I was trying to do. But sort of popular criticism or not, you know, I'm assume the worst and feel there's no reason to read the rest.
We had a session with students earlier today, and one of the students asked a question. If you don't mind, I'll ask it again.
We'll see if my answer is the same.
Do you ever look back and think, oh, darn it, I got it wrong before, and wish I had decided differently?
Well, I'll give the same answer because it's the true one, and I always worry it might sound, I don't know, harsh or something, or worse. But the answer is no. My former boss and predecessor, Chief Justice Rehnquist, once talked to me and my fellow law clerks about that and said, you know, there's just too much in front of you that if you start wringing your hands about something in the past, you'll just never be able to keep up. Now, sometimes the case is pertinent again. If a new issue comes up and it's one of the precedents, you do look at it again, and maybe at that point you see that, well, it may not be as compelling as you thought and may not be appropriate to follow it. But in terms of just thinking, I mean, I'm sure I've made mistakes. It's a human enterprise and no one's going to be perfect. So I'm sure among my decisions in the past are some that aren't right. You know, second thoughts and looking back on them, no. And in terms of mistakes and errors, you know, people think maybe that I'm being smarmy when I say it, but I'm not. It's a great comfort to me that I have my colleagues. And I can't do anything unless I get 4 very, very bright, hardworking, accomplished individuals to agree with me. So that's sort of as much protection as I can get against error.
Who are you writing to when you write your opinion? Are you writing to your colleagues, the other justices, to explain why you take that position? Or do you write to the lawyers that argued the case? Are you writing to the law professors to explain how you're expanding the doctrine? Are you writing to the public? Who's the audience for your opinion?
I'm writing for my 3 sisters. They are not lawyers. They're intelligent lay people. They're not in Washington. They like to keep up with things in government and civic affairs, but it's not a preoccupation for them. And I would like somebody in that position to be able to understand what their Supreme Court has done. So I'd like to think, and I'm sure this is an area in which I don't succeed all the time, that the opinions are accessible. They don't need to know the nuances, but if they can read an opinion and say at the end, okay, I understand what the issue was, I understand how it came out, and I have some idea of why, that's what I'm writing for. You know, I think maybe sometimes that means the lawyers are disappointed that I didn't, you know, chase every rabbit down every hole of the nuances of some arguments that they think should have been addressed. And certainly I'm sure the law professors think that. But I think that's the proper audience. Our job, we work for the public, and they ought to be able to understand our product.
I'd like to ask you about a local connection. You quoted a famous Minnesotan who has won a Nobel Prize for Literature in one of your opinions, Bob Dylan. Can you tell us about that opinion and why you quoted Bob Dylan? Was it just to make the opinion more interesting?
No. And I should say I had a wonderful I hadn't seen this sort of 7-story mural down the street before, but I enjoyed that. No, it was, again, I guess, along the same lines to make a particular point accessible. And the opinion was about the legal concept of standing, which is that our jurisdiction's limited to actual cases and controversies, and therefore you have to have something at stake in a controversy before we're allowed to decide it. And it was a situation where a particular company was complaining about something, but it turned out they didn't have a concrete stake in it. And I thought that would be a good way of elucidating that concept in, you know, everyday terms. Well, I said, when you have nothing, you've got nothing to lose. And I got into a little debate with the New York Times about it because they said, well, what he said is when you ain't got nothing, you've got nothing to lose. And it turns out that that is what most people understand from the singing. But if you look at the actual published lyrics, it just says, when you got nothing, you got nothing to lose.
You had it right. Okay.
Which makes better sense. I mean, when you ain't got nothing, it's kind of a double negative that's actually wrong. And so I'm going back and forth with the correspondent from the Times, and I said, finally, no, I'm looking at the actual published lyrics. I'm more of a textualist. I didn't hear from Bob Dylan about it.
Not yet. Well, maybe you will. One of the connections I wanted to ask you about, back in the 60s, Bob Dylan sang at a place, The Scholar in Dinkytown, just a few blocks from where we are right now, and under his given name, Bobby Zimmerman. So some of us who were here on campus at that time had a chance to hear him then.
Well, the last time I saw him was in Washington at Wolf Trap, and I took my kids, who are 17 and 18, just a few years ago now, and he sang his latest album, which was a collection of, like, Perry Como and Sinatra songs. They didn't understand what it was all about. And to be candid, I didn't understand what it was all about either. But.
One of the comments you made when you became Chief Justice is that you hope to achieve greater consensus on the court. You hope there would be more 9-0 decisions, 8-1, 7-2, rather than 5-4. Do you feel in 13 years now that you've been Chief Justice that consensus has developed? And if it has, is that due to deciding cases more narrowly so you can bring more justices on board?
Well, I'd have to say it's a project in progress still. Some years we've had a bigger number, and other years not, and has more to do, I think, with the nature of the cases than anything else. I still think it's an important objective. One, because I think judicial decisions should be narrower rather than broader, and the way to do that is to try to get as many people on board as you can. That, you know, if you're going to reach a broad decision that's going to cover all sorts of different factual scenarios, a lot of people are going to say, well, whoa, I'm not quite sure I agree with that. and then they might write something narrower. But if you keep it narrow, that it only decides what's absolutely necessary to be decided, usually you can get more people to agree with that. One of our most important decisions, Brown versus Board of Education, is a perfect example of that. Earl Warren worked extremely hard to get everybody on board because he wanted it to be a unanimous decision to send a clear message to the American people that we're turning a page as a matter of law. And he was able to do that. And a lot of lawyers and even judges don't appreciate this, but the opinion in Brown versus Board of Education was, I think, 11 pages long. And Warren said, you know, if he'd written one more paragraph, people were going to start splintering off. You pay a price for that, and you did in Brown as well, which you have a lot of issues in the area that aren't resolved and need to be, you know, spend in many cases a generation resolving. But Warren thought it was more important to keep everybody together, and as a result wrote an opinion, while revolutionary was, in its own terms, really narrow.
Would U.S. versus Nixon be another example of that?
Yeah, I think so. And, you know, and it's true even in little minor ERISA tax cases. There again, I think courts sometimes get in trouble when they try to sweep more broadly than necessary, and trying to get as many people on board forces you to have a narrower opinion.
When you bring up ERISA, my mind thinks, are there cases that you think the Supreme Court's not uniquely suited to decide, where they involve complex issues, highly technical issues, where the court might make a decision that would have ramifications that may not be known to the 9 justices, or even the clerks who may be public law people that don't have a corporate background or background in that area?
You know, my answer, I think it's no, because usually no matter how complex and involved the legal issue, the case may seem, it implicates a broader legal question about, you know, the statute may be complicated, but the question is going to be, well, how do you go about reading the statute? What sources do you look at in a particular case? We don't take technical legal cases because we like technical legal cases. They're usually because they implicate a broader question. When I was practicing law, this is a speech I gave a lot of times because I was not an expert in any area of the law. I like to think of myself as somebody who is good arguing in a particular court, in the Supreme Court. And so I'd have to, you know, convince someone who comes in with an important trademark case, who could hire the world's leading expert in trademark law, or me, and I would tell him, look, the Supreme Court does not think your case is a big deal for trademark law. It thinks your case is a big deal for how regulations relate to the statute, how a particular provision in statutes should be read. So you need somebody who, you know, can look at it in that broader perspective that the justices do. And, you know, I'd say half the time they'd say, well, I actually want somebody who knows something about trademark law. And that was understandable. But then it would be, and you know, they would get there in front of the court, and they're too expert in trademark law, and the justices just aren't that interested in a lot of those nuances. And sometimes they would just be speaking over each other.
Yeah. Do you think the media tends to focus too much on sharply divided 5-4 decisions?
Well, I mean, they've got their own audience to worry about, so I'm sure they focus on, you know, what's important to them. It's not that they focus too much on 5-4 decisions. And I don't mean to be critical of our press corps. In fact, you know, I can be curmudgeonly. I wish I could be critical of them. But they're very, very good. And it's partly because they are a dedicated corps. And we're fortunate in terms of having the public understand what we do, that we have people there who know how to read Supreme Court opinions and all that. But in some instances, and with other reporters, you'll have a decision that's sharply divided 5-4. The first thing they'll tell you, it was sharply divided 5-4. Then they'll have an interview with somebody from, if it's an environmental case, they'll have an interview from somebody from industry or somebody from the Sierra Club. One of the sides thinks it's a horrible disaster, the other a great victory, and then you'd have other commentary, then you flip over. And, maybe before the end of the story, you'll see that what was involved is an interpretation of a particular statute, and you don't see the statutory language until almost the end, if at all. And if anybody had looked at it, they would see what the language said, and a reasonable person would see, oh, I can see what the problem was. They don't know if it means this or that. But instead, it has to be portrayed more in a political way that I suppose somebody must think is more readily understandable. But from the court's perspective, I would just like to see the one sentence that caused people to split, so that reasonable people, again, one of my sisters, could look at that and see, yeah, I see why there are two sides to that story.
We've talked before in this series about the collegiality on the court and heard that there is great collegiality even as passions about the cases cause deep divisions in our country. Can you talk a little bit about the collegiality on the court as you see it right now, and whether you take any steps to foster that collegiality?
I think the collegiality on the court is very, very good. We do think we are in this important enterprise together. There are some ways in which the 9 of us are surprisingly similar in terms of, what we come from 2 different law schools and all sorts of things that really are a surprise. Other ways in which we're very different. The collegiality is very good. We spend, in many ways, it's unlike any other job. There aren't many jobs where everybody is doing exactly the same thing. I mean, if you're at a company and you're in sales, you're all in sales, but you're selling to different people and all that kind of thing. Here, we do exactly the same thing. We read the same briefs, we go to the same arguments, we read the same cases, and that does cause a real bond to develop between you. And also because of obvious reasons, we're often the only people we can talk to about certain subjects, because you don't want to talk about a lot of different things with members of the public, certainly not politics or other things like that. But we can talk to each other about it. And again, that helps form a bond. And I think we appreciate the pressures that each other are under, and that creates a certain amount of empathy that you might not have in other enterprises. There have been times on the court when there have been unpleasant people there. And that's made life unpleasant because you do work in such close quarters, but now is not one of those times.
Yeah, I'm thinking way back when Justice Jackson was in Nuremberg and wrote a letter to the New York Times criticizing Justice Black. So.
Yeah, that hasn't happened yet. In terms of things we do together, we have lunch together, any argument day, any conference day, which works out to about half the days in a month. We have lunch together. It's in a lovely dining room. We have very nice plates and all that, and on the plate you put the food you got in from the cafeteria. But the one rule that I enforce there is that we don't talk about work. So it's a nice opportunity to learn about different things. You can learn about how the Phillies are doing from Justice Alito, and the latest performance of Traviata from Justice Ginsburg, and all sorts of things that people like to talk about. And it's a nice break from work. And also, it's very important that the term runs, for 10 months. We don't leave until we're done. We're usually done before the 4th of July. And then we leave Washington. And we don't see each other, except for occasional overlapping, for 2 months. And as Justice Brandeis, I think it was, put it, he said he could do the 12 months worth of work in 10 months, but he couldn't do it in 12 months. We need a little break from each other, and we get it.
What about after a particularly sharp case, 5-4, with a sharp dissent? Do you sense any coolness between the justices who maybe wrote the majority opinion and the dissent? Does it take a little bit of time to work that out, or not?
No, to be honest. And again, it's something my predecessor mentioned once when I think goes back to when I was clerking. We were all excited, oh, this is a very big case and this and that. And he said, you know, we had a very big case last year, and we're going to have a very big case next year. And if you start getting, causing those big cases to interfere with your personal relationships, it's going to be a very long career. So they're big cases. Obviously, we take them seriously, and we work very hard on them, as we do on all the cases. But I've not seen a situation where it's sort of come between two colleagues in a way that interfered with their relationship with each other.
How would you describe your style as Chief Justice? Have you studied the style of some of your predecessors and tried to incorporate things that you thought they did well?
I have. I remember when just after I'd been confirmed and went into the court and was looking at the conference room. In our two conference rooms, we have the first 8 Chief Justices' portraits in one and the last 8 in the other. And I was walking around and imagining them sort of looking down in horror, like, who is this guy? But the one thing that struck me is that I had no idea who half of them were. And I think many people would. There's a lovely portrait of Morrison Waite in the first conference room, who was the Chief Justice for a dozen years. And hundreds of lawyers would be, and I asked, would be in the room. I said, who is that? Nobody had any idea, including law professors. And then, you know, how many know, John Rutledge or Oliver Ellsworth or Morrison Waite or Melville Fuller or even Fred Vinson? I would have thought it really would have been one of the devastating questions during my confirmation hearings if one of the senators, okay, you're going to be the 17th Chief Justice if you get through. Name as many of the 16 as you can. That would have been very embarrassing. There are only 16, and so anyway, to get back to your question, so I did try to study those and figure out, who they were and learn a little bit about them. And I think there were valuable lessons. Some people cheated. John Marshall insisted that the justices live in the same boarding house in Washington, and he was one of the largest importers of Madeira in North America. And they would discuss the cases over dinner, and everybody loved him. My predecessor was very pleasant, very direct, and very fair, and I think those are very important traits for a Chief Justice to have. Because as a Chief Justice, you hold the reins of power, but if you tug on them too tightly, you'll find out they're not attached to anything. And so you do have to kind of appreciate that in figuring out a style of leadership that works.
You mentioned who knows who Chief Justice Morrison Waite is. I mentioned earlier that Justice Kennedy wanted a couple of cases included in the course, and one was a Yick Woe.
Oh, well,
and that was Chief Justice Morrison Waite.
Right.
One of the first 14th Amendment cases that were decided. Let's talk a little bit about the workload of the court. In the past year, the 2017 term, the court decided about 75 cases, give or take. And that's pretty typical of the last few years. When you clerked for Justice Rehnquist about 35 years ago, the court decided about twice as many cases every year.
Right.
Why is the court deciding so fewer cases these days? And obviously, the justices decide which cases to take, but do you have on your court some colleagues who want to take more cases?
Yes. We certainly have the capacity to do it. We can. I thought at the time when I was a law clerk, 150 was a little too much. You were hearing 4 cases a day, and I thought the quality of the work deteriorated when you're getting close to the end and have a lot more on your plate. But we can do more. I'm one of the ones who think we should do more, but the cases aren't there in the sense we have particular criteria for the cases we want to take. Obviously, if any court finds an act of Congress unconstitutional, we will take it. We think as a matter of comedy to the branches across the street, we should be the ones to say that if any court is. And other than that, they're conflicts. I mean, if the court in California decides that under this tax provision in federal law, this is deductible, and the court in New York under the same provision says, no, it's not, those are most of the cases we take. That's the bulk of our business. And for whatever reason, that isn't happening as often as it did in the past.
It was about 9,000 or so applications for cert?
Closer to 8,000.
8,000.
But it's still a lot. I think technology actually might have something to do with it. I know in the olden days when I was clerking, cases would come up and you got the impression that they disagreed with each other because they didn't know all of the law that was out there. And if they had known, it would be maybe a little different. But now with the push of a button, lawyers know every case that's out there, and so maybe the lower courts are finding ways to reconcile their differences without the need for us.
You argued more cases before the Supreme Court as an advocate than any other justice who's been appointed, I believe. What do you know now that you didn't know then about the court that would have perhaps favorably influenced how you argued cases?
Well, it's more a question of believing what people told you. People always tell you that you should be brief and succinct in your brief writing. But it's only when I had to read all the briefs that I began to appreciate how serious that advice was. Our word limits, they're wordless, but they come out to about 50 pages a brief. And you pick up a brief and it's 50 pages long. You pick up the next brief and it's 50 pages long. It's 50 pages. It's 50 pages. It's 35 pages. Whoa. You stop and the first thing you do is you look at the cover and you see who the lawyer is and you say, well, I like her, And the next thing you do is you think and realize, well, and she must have a lot of confidence in her arguments because she gets them in 35 pages and doesn't need all the extra pages. And it's invariably not only shorter, but, well, better written because it has the arguments and it's more succinct and it doesn't have all the distractions. So that's one thing. I would have taken more seriously the advice to keep things short. And I would have taken more seriously the advice during oral argument to have a little dispassion and distance from your case and not to be extraordinarily combative. I mean, and I see it all the time in oral argument here. You ask a question, and the first thing the lawyer does is resist the implication. You're asking a hard question. They want to test the limits of your argument. And you say, well, that's not what's going on in this case. And, of course, we know that's not what's going on. That's why it's called a hypothetical. Or they push back and they don't cooperate. And that immediately erects a wall between the justice and the lawyer. They have to fight. He has to fight now to get you to answer the question. If you're more welcoming and say, okay, well, yes, no, first of all, and explain it, it becomes a process where the two of you are kind of working together to figure it out. And you, as a lawyer, have an opportunity to get involved rather than just pushing back.
Who's asking the most questions on the court these days now that Justice Scalia isn't there? Any statistics on that recently?
There are. You have to kind of be careful how you judge them because, well, it's not me, I can assure you that. But there's sort of running time and number of questions. You can ask 5 questions in a short amount of time, or you can ask 1 question that takes up a lot amount of time. Mm-hmm. And I just wouldn't want to comment on that.
Okay. I didn't think you would. Last term, you wrote an opinion you wrote a majority opinion in a case involving the scope of the Fourth Amendment in the digital age, a very important case. Could you talk about that case and the challenges of new technology in deciding constitutional cases?
Sure. It's Carpenter was the name of the case, and it involved telephone companies have surprisingly detailed records about where you've been for the last several years, where your phone's been technically, but that's usually where you've been. And the question was, what do the police have to do to get access to those records? And the the case was a good example of how compelling the evidence was. They got the phone records of this one person who was in 5 different locations over a period of time. At each time he was there, a bank was robbed. And you sort of put it together, it's a pretty strong case before the jury. But the question is, what do the police have to do? And the well-established law was, well, you're out of luck because they're not your records, they're the phone companies, and the police can go and get them from them with a simple subpoena rather than a search warrant. And I, and fortunately others on the court who joined the majority, thought that that doctrine that had developed at a time when people were, had what we're talking about are papers and records, really didn't make any sense given the new technology where the companies automatically had information you did not in any real sense want to share, and allowing access to that without the protections of the Fourth Amendment would really leave all of us with much diminished privacy. So you had to look at the question basically about what do you think the drafters of the Fourth Amendment would have thought about that, about the government having access to information about every place you've been for the last 5 years. I mean, they were worried about British soldiers kicking down the door and rifling through their desks. And I asked this question of teenagers, others I know. I mean, what would you regard as a greater invasion of privacy? Someone coming into your house and looking through what's in your desk, or someone looking through what's in your iPhone? And the answer is always the same. And so it seemed to make sense to me that the Fourth Amendment, at least the doctrines that had developed under it, should be adjusted to take account of modern technology. And that is going to be the challenge for those of us on the court going forward, not just in privacy areas such as that, but certainly in speech areas. I mean, what does it mean now to send a message over the internet in terms of hate speech, libel, anything like that? Obviously, technology in terms of commercial technology. You have, I forget what the number is, in a sort of iPhone or something, how many separate patents are implicated in that, and what are the antitrust implications of that, all sorts of things. So, and it's a challenge for, I mean, I remember when I was at the Supreme Court, the excitement when they brought in the very first word processor. So it's a challenge for us to be able to keep up with enough knowledge about the technology to be able to, correctly decide some of these cases.
Well, we're at 5 o'clock. Wish we could go further ourselves, but we said we would take questions from students or others in the audience for the next 15 minutes or so.
Good.
If you have a question, could you go to either side of the auditorium, and if you would queue up behind the microphone there, and I'll try to alternate from one side to the other. So let me see, is someone behind the microphone? Let me, over here, let's start on the left side.
Oh, there,
our left.
There they are.
Go ahead.
Okay.
Hi, thank you for taking my question.
Sure.
Currently I am...
Excuse me, could you just, if you're a student, just say whether you're 1L, 2L, 3, or LLM, or somebody else.
I'm actually pre-law. Currently I'm political science.
Okay.
I'm currently in a judicial law class, and we were talking about the Socratic method and how some people are for it and some people are against it. What's your opinion on that, and is it still viable today in law school?
Yeah, it's one of those things, if it's done well, I'm in favor of it. If it's not, it's a disaster. I mean, maybe not everybody knows. The Socratic method is like the professor going around and asking questions and grilling students and their answers and, trying to pursue a line of discussion through questions that develops, makes a point about law. And in law school, I had both types of people. I had somebody who was remarkable at it. The whole class was excited. They knew they could be called on at any minute, and they were all participating in this great educational exercise. But you do have to be very good at it. Then you had people who aren't, and they would ask a question and you'd answer, and then they would say, and the person would try to say something. I mean, that was not moving the discussion forward. But I like it, and it's good training to be a lawyer. I mean, if you're in court, you're going to get a lot of questions. You have to think quickly on your feet. And it's good to have that kind of practice. And also to develop confidence. I mean, all of us are nervous in class and other settings and sort of participating. And, you know, you don't want a lawyer who isn't confident, so it's a good skill to develop. But they got to be good at it, and it's getting harder and harder to find people who do it, partly because of the change in law. A lot of people think there are more and more law courses that convey information as opposed to, you know, how to think under stress. And I think the latter may be more important than just getting a particular bunch of information into your head.
Thank you.
Is there a question on this side?
Hi, I'm a 1L here at the university. Thank you, Mr. Stein, for having us all here. Thank you, Mr. Chief Justice, for taking the time to speak with us.
Sure.
My question is based on your opening statements. You said that the Supreme Court's role is to serve the Constitution, not the people.
Right.
However, many people have come to rely on the Supreme Court as the court of last resort when political injustices can't be solved through politics, either due to gridlock or other means. Do you believe, based on your view of what the Supreme Court should be, that reliance on the Supreme Court to have that role is mistaken?
No. The point I was trying to make in the examples that I gave is that an important part of our role is to support viewpoints that are not the viewpoints that are dominant with the majority. For example, I'm pretty sure at the time that West Virginia versus Barnett was decided that if you took a poll, most people would say school children should be forced to salute the flag and Pledge of Allegiance. But because we have a Supreme Court independent of political pressure, the court was able to say no, under the First Amendment, that child and the child's parents can't be forced to express views that they don't agree with. And the same thing perhaps in the Steele seizure case. President Truman needed a peace in the labor area in connection with the Korean War. And again, I don't know what the vote would have been about whether or not he should be able to take over the production capacity. So those were all meant as examples of the role of the court to protect minority rights against the majority. So and that is what I meant by saying that we don't speak for the people. We don't take a poll about what we think is the right result. We speak for a Constitution that was designed to protect minority interests against the majority.
Thank you.
Thank you.
Over to this side.
Chief Justice Roberts.
Could you identify yourself?
Oh, yes. My name is Elijah. I'm an undergraduate student at the University of Minnesota studying
Great.
Sociology of Law, Criminology, and Deviance.
Glad to have you here.
First, want to thank you for hosting us, and Chief Justice, thank you for coming.
Thank you.
My question is as someone who's looking to go into law school and very much wants to succeed in law school, the most popular advice I've been given by other law students is, when I ask them, what advice do you give for someone who wants to go to law school, the most popular answer is, don't. So my question to you, Chief Justice, is what motivated you to go to law school and what motivated you to get through law school?
Well, what motivated me to go to law school is that there were not a lot of jobs for history teachers. I had hoped to pursue a career in academia, and in 1976, when I got out of college, that was a fool's errand. There just were not any jobs available, even assuming you're going to go down and get a doctorate degree before you could teach. And I thought what they were doing in law school sounded a little bit like history. They look at old cases, and maybe that's how it would work out. And so I went to law school, and I just really enjoyed it. I loved it. I loved the process of taking a set body of law and trying to find particular guides to conduct in it, and the thinking. And I didn't leave history behind. It's what I like to do when I'm looking for recreational things to read. But the idea of being a historian, wasn't in the cards anymore. How to get through it? It's tough. I found working with other law students was very helpful, whether you form a formal study group or just sort of sit down with people from time to go through your reactions to what the teacher is trying to instill. The only thing I would say is it used to be the case when I was in law school, and I think it may be still the case as well. You should think long and hard about why you want to go to law school. I think, to be honest, my case, it worked out all right. But I would not recommend that people just, go to law school because you wanted to do something else and they were just kind of looking for something else to do. You really should have a good idea of what you want. I will be honest with you. One, it's very, very hard. The profession is hard. The only advice I give to people now is that if you want to go to law school, make sure you're going to do really well. Because it's hard for, the market is hard and the law profession is changing, that even good lawyers, the business part of it is not very, often not very attractive. But have a good sense about why you want to go to law school, and try to keep your eyes on that. There are a lot of lawyers working who are pretty unhappy because they didn't think about why they wanted to go to law school. And even if they did, by the time they get out and they're figuring out what to do as a lawyer, they kind of forgot why they went to law school and end up doing things that are not at all like what they thought they would like to do. So, I mean, it's a tough choice. Any career decision at this stage is. But I would spend a lot of time talking to lawyers and law students and try to figure out for yourself why it is that you want to go to law school.
Thank you.
Question over on this side.
Yes, I'd first like to say thank you for hosting this, and Chief Justice, thank you so much for being here.
Sure.
My name is Kate Sievert, and I'm a senior here at the U studying political science, and I'd like to know if you think that having more women on the court has impacted the way that you look at cases, kind of your viewpoint on that?
Yeah, I guess I don't really know. I understand the argument that, it brings a different perspective and changes it. On the other hand, it may, but I would say it's subconscious in the sense that I don't hear anything and think, oh, that's a peculiarly female perspective on the law. In terms of the legal work and the presentation, I don't see a difference. Maybe I'm just not attuned to it, but I think my female colleagues perform pretty much the same way my male colleagues do, and I think that's pretty much it. I don't see any difference in their legal analysis or anything like that.
Thank you.
Back to this side.
Thanks, Your Honor. My name is Caleb. I'm a 1L here. So you've said in the past that the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. I'm curious, what do you think race is? What account of race do you think is correct?
What do I think race is?
Yeah, what makes someone a member of a particular race?
Well, I don't know. I mean, that's actually a very difficult question, I guess, they're looking at in some of the affirmative action areas in terms of what types of categories ought to be given preferences and what it takes to qualify for particular preferences. But I don't know in particular any more than that.
Okay.
Over on this side.
Hi, thank you, Mr. Chief Justice, for coming all the way out here. My name is Benjamin. I am a freshman here at the University of Minnesota, and I just wanted to touch on something briefly that you mentioned, and that was about your personal beliefs conflicting with the way that you may decide in certain opinions. And I was wondering if you could give just a brief example about some case that you decided or you voiced your opinion in one way, but personally you felt completely different.
Oh, sure. There are lots of them. I wrote the opinion in a case, I think it was called Westboro Baptist Church. And this was an extraordinarily offensive group. They would protest at funerals for servicemen in the most vulgar way. And, thinking of it, ask what my personal view is. If you have these, a family that just wants to bury their son or daughter who's died, 18 or 19-year-old died in the war and is being buried, and they have these vulgar protesters criticizing the son or daughter in the most offensive ways. I'd throw them in and lock them up and throw away the key as far as I'm concerned. But that's not as far as the First Amendment was concerned. And my job was to apply the First Amendment. The protesters were on the public sidewalk. They had a particular point of view, as offensive as it was. And so I wrote the opinion for the court. I think the vote was 8-1, upholding their right to protest in that matter. I didn't like it, but I thought, and as my colleagues did, that that was the right answer. And there are a surprising number of cases that are like that. Flag burning, I don't like the idea that people burn the American flag. You know, it's more of a symbol for our nation than for most others, because we don't have sort of a common identity, either as French or Italian. We don't have a common religion. It's the Constitution and the flag that kind of unite us. And why does somebody have to burn it and offend all these other people? On the other hand, again, the First Amendment was pretty clear, and so I thought that was the court reached the right result in that case. And I don't want to be glib, but the reality is, as I found it, I think many do, it's actually not that hard. It's what lawyers do every day. People who defend, people accused of murder obviously may not like their client if he or she is guilty or whatever. But lawyers, do separate themselves from their job as part of the legal process. It happens surprisingly often, and I don't find it, you find it hard. I don't like it that's what. Well, that's not true either. I do like it that the First Amendment allows this type of activity. It's the activity I don't like, but you can't allow that to interfere with your interpretation of the First Amendment.
Thank you. Let's do one last question from this side.
Hi, my name is Anna Kvinge, and I'm a 1L at the University of Minnesota Law School. My question goes to your introduction, where you said that previously the court has erred in following policy. I was wondering if you could say in what way the court now and the justices do or can do in the future, what they can do to avoid that was perhaps not done before.
Well, that's a great question, because you do look back on these mistakes, and in retrospect you think, well, that was pretty obviously a mistake. You'd like to think that if you were in their position at the time that you would have done something different. But it requires a fair degree of arrogance to say, I wouldn't have done that when others do. I don't know. Excuse me. Again, my greatest comfort is my colleagues. But there were 9 members of the court, for Korematsu and everything else. I don't know that there's a magic formula for making sure you don't make a mistake, other than work as hard as you can, looking at the materials we have and the principles underlying the Constitution, and listen as carefully as you can to the views of all of your colleagues and do the best you can.
Well, please join me in thanking Chief Justice John Roberts today.
Thank you. Thank you. Thanks very much. I appreciate it. Thank you. Okay. Thanks. Hello. Let's say hello, Mr. Vice President. Very good to see you. Good to see you.
I'm happy to tell you there's a reception right on the atrium of Northrop right now. So see you there.
Here's a look at our live coverage Wednesday. On C-SPAN, the